welcome everyone. My name is Caroline Lefebvre and I'm based in Gatineau. I work for the Canadian Intellectual Property Office, and I'm joined by my colleague Lisa, who's also part of this person, who's there with us. Just a few words about who I am and my role. So I've been with CIPO for close to 14 years now as an IP advisor, intellectual property advisor, where that allowed me through the years to deliver presentations such as this one on different IP related topics, having one-on-one meetings with different clients, and we try to reach out to entrepreneurs, people working with entrepreneurs, researchers, professors, students, inventors, creators, artists, whoever in their activities develop any type of IP pretty much is a potential client of CIPO. So today's presentation is, we'll talk about IP, how to develop an IP strategy and what is an IP strategy. And just for those who may not be familiar with CIPO, the Canadian Intellectual Property Office, we're the federal body that receives, that grant and administers IP for Canada. So we receive IP applications, so patents, trademarks, industrial designs, copyrights, and we go through an examination. And at the end of the day, there's a decision made and to either reject or refuse, to reject or accept the application. Just want to make, okay. As any one of you would like to maybe share what they think, what's an IP right? Could you name an IP right that would be useful for a business or creator and inventor? Okay, so IP right could be a trademark, a patent, an industrial design, copyright, or trade secret. There's also the Plant Breeders Act that's administered by the Canadian Food Inspection Agency. So a trademark will protect the branding of a product, a company, or service. So it could be a name, a logo, a tagline, a shape, scent, a taste, hologram, etc. It's whatever distinguishes your product and service from the others. Patents will protect a functionality. It's anything that has to do with something mechanical, a new feature, an improvement on something that exists. It really protects, as I said, the functionality. Industrial design is very different though. It's anything to do with visual aspect. So a shape, an ornament, a configuration, that's original, and that's attached to a finished product. Copyright is any original content from business plan, user's manual, photography, sculpture, computer code, web content, etc. And I'm missing the trade secret, which is not per se protected by CIPO or any other IP offices around the world. It's any information that you must keep confidential, either prior to file for IP protection or for the duration of your activities, such as the Coca-Cola recipe. It's been kept secret for over 120 years now. So any questions on different type of IP rights before we jump into the IP strategy? Okay. And as I've met, and I was discussing with Lindsay before we started, you're more than welcome to ask your questions as we go. You don't have to wait until I ask if there's questions, and I'll monitor the discussion. But also just make sure that you don't disclose any confidential information because that could be detrimental or prevent you from obtaining IP protection later. Okay, so just be mindful of that. Okay, excellent. So what is an IP strategy? An IP strategy is how to use your IP assets, no matter what the right is or are, to help you reach your business goals. And I've always compared, or I always made a parallel of a business strategy, like an overall business strategy as an umbrella, under which you will have different strategies like IP, HR, marketing, R&D, etc. And all of these are very important, may not be at the same time, but all of them will help you together to attain your business objectives. We sort of recognize that IP strategy is very underutilized and even underknown. It's not very well known. And many people think or don't think of developing an IP strategy by lack of knowledge. And why I refer to the business goals in an IP strategy, it's because in order to define your IP strategy, you need to understand and to know what your business goals are. And another parallel, if you're planning a trip, we're all hoping to plan trips in the near future. Well, before you've identified your destination and what you want to do and the time you have and the money you have, you can't decide, will I take a plane? Will I take my car? Will I sleep in a hotel? Will I sleep at friends? So unless you understand and you identified your business goals, it's hard to develop an IP strategy that's relevant for your business goals. For example, if your activities are, I'll monitor time. Okay. So for example, if one of your business goal is to develop and you're involved in developing winter sports technologies, like relating to downhill ski, let's say. If your business goal is to, within 3 years, to be present in most of the northern countries in the world selling your new ski boots, well, you will make sure that your IP strategy identifies all these countries and will identify which IP rights will be great for you. For example, probably patent, trademarks, industrial designs, and copyrights, and probably trade secrets. But you'll have to exactly understand and sort of dissect your business goals and identify which IP rights, which IP assets will help you. And if you realize down the road that some ideas that you had or some products that you had in mind won't be that successful on markets, you're allowed to let them go. An IP strategy must be agile, must be easy to adapt to market conditions. For example, pandemic was one of the best examples that could be provided. Is early March 2020, who would have thought that we would still be in pandemic? And we all thought, okay, we'll be okay, mid-March, okay, two weeks we'll be back to work regularly, normally, but no, we're still not. So many businesses had to review their business strategies and business goals, hence relying different IP rights or developing new brands. There's a whole strategy of developing new products relating to COVID-19, new trademarks. Maybe you have not thought of doing masks or medical equipment, but hey, there's a market, there's a potential. So you realign your business goals, you realign your IP strategy. Does that make sense? I don't see any faces, so I'll just keep on going. And as I've mentioned, don't hesitate to interrupt me. Okay, so how do you go about and plan or develop and implement an IP strategy? I would say there are 6 steps as mentioned here on the screen. First, you have to understand what is it that you have. What is it that you're offering in terms of product and service? I see a question or a comment. I'll just check. Okay, there's a good question here. Centrically, how can I be sure my IP strategy plan is sound? Well, we have different options for the person who asked that question. Making sure that it's aligned with your business objectives is a good test, but also that, as I said, you can adapt it to different situations. Myself and my colleagues across Canada, we can help you thinking and designing your IP strategy. And I'll speak for Quebec, but I know there's other specialists across Canada, but you have consultants across Canada that are IP strategists, and they can also work with you. So bottom line is making sure that wherever you want to go in the next few years, your IP strategy will help you get there. Does that help you? Does that clear? Does that answer your question? Okay. So if it did not answer the question, please provide some more questions, and I'll be more than happy to respond. So the 6 steps of, okay, I see there is a, sorry, I'm having, okay, perfect, excellent, thank you. So an IP strategy, let's say, should have 6 different steps. So first, it's an internal IP audit. So clearly you have to understand what is it that you have, what is it that you're offering that is an IP asset. Do you have a cool name? Do you have a new feature? Are you developing a new app for a cell phone? Are you, do you have a blog that's very actively and that's followed by a lot of people? So do you have copyrights aligned? Do you have your patent? Do you have patent pending? Do you have a trademark application in or not? Are you planning to apply for those protections? I have done all the steps, but now what? It's time to implement and try it. As I said, an IP strategy question was, I have done all this, so what now? I would say it's time to implement, try it. And as I said, it's got to be agile, it's got to be flexible. So I have to readapt to different market needs, to different situations. So it's to try, it's to let's same as a marketing strategy. Let's say you have your strategy in mind, you use it, you launch it, and you look at the results and you modify if needs be, or you keep going. And if it's great, if it's exactly what you had in mind, perfect. Second step is external audit. What's around you? If you're in a specific field, going back to, let's say, the winter sports industry, if you're planning to develop a new downhill ski boots, and you want to make sure that it's very popular in Nordic countries, well, it's not only the objective to have that technology around the world, it's to say, okay, what are my competitors up to? Are they developing one too? Is my technology sufficiently innovative enough to attract more people? How will I sell it? So I have to find out what my competitors are. Which countries would be interested in my technology? What are my competitors filing for in terms of patents and trademarks and industrial design? Am I innovative enough? Am I competitive enough to be better than my competitors? Can I work with another company to help me grow faster, to help me reach out to more broader markets, etc. Okay. And then part of that internal and external audit will lead you to an analysis. So what are the IP gaps? Going back to winter sports. Okay, I found that what I have in mind, what I'm working on in terms of new technology for my downhill ski boots is really, really innovative. So yes, there's a niche for that. So that's part of the game. And then clearly if you have a new design for that booth and it's original, so there's an IP gap there as well. So you can fit in there. You can enter those markets at relatively no fear that you'll be infringing on other people's IP, and that other people, if they ever infringe on yours, you will have capacity to ask them to cease and desist or to even sue them legally. So all this being said, it's time to initiate your IP strategy. So create your plan. How will you use your IP? Which countries are good markets for you? Do you need collaborators? Do you need investors? Do you need to work with different institutions to help you try a new feature? Do you need new material? So what do you need to develop in terms of IP, and identify those key players around you how much you need to invest, how much you're planning to make in the next few years. So that's your plan. How will your IP strategy, how your patents, trademarks, copyrights, industrial designs will help you get exactly where you want to be in 3 to 4 years. And then implement it, what we call IP in action. File those patents, file for those trademarks, those industrial designs, and don't not only see IP rights as defensive mechanism, but see them as tools to make money. So in whichever countries you apply and you get granted or registered your IP, well, you can grant licenses, you can sell them, you can grant licenses to use, sell, and manufacture. So it's another opportunity for you to make money and increase your revenue. And constantly reassess and realign your IP strategy. Again, something happens, world pandemic. Well, what you had in mind back in February 2020 may not be what you're planning to do right now, 15 months after. And it's okay. You just have to be able to realign and evaluate, okay, what I intended to open a resort and near a lake somewhere in Canada while there's no traveling, and so maybe I should do something else. I'll use my tourism experience on doing something else, attract more local people. I don't know. Okay, so you have to realign, and all the time making sure that your IP is always aligned on your business objectives, and it's helping you to achieve those objectives. Is there questions before we go into the next slide? So before you start identifying your IP assets, we have what we call an inventory checklist, IP inventory checklist. that could be found on CIPO's website. And it will tell you exactly, okay, so you have a website, you have a blog, you have a logo, you have an algorithm, you have photographies. How can you protect them? And what's the value? And what are the different options to keep them protected or confidential, depending on. Let's say part of your business is to have a, I don't know, your baking or your offering. I'll try to find an example quickly. Well, that's an example it's my region. A few years ago, I was delivering a presentation to a group of students, and we were discussing trade secret, and was referring to the Coca-Cola recipe example, which is the classic in terms of trade secret. But one of the guys said that he was explaining us that he worked for a very local pizzeria in his neighborhood. And it's not a chain, it's just a one, like privately owned, family owned. It's been in operation for years and years and years. And he said people keep going back to this pizzeria because they really love the pizza sauce. And the pizza sauce is very unique. It was developed by the owner, and only he knew the recipe. He never shared with anyone, not even his wife and kids and employees. So the recipe was kept secret in a small, tiny safe and somewhere in the house or in the restaurant, and no one had access to it. So what I mean by this example first is that you don't have to be a large corporations to hold IP. To hold IP, you could be a small operating company, and there's ways to protect your information and your IP, depending on what you're trying to protect. There's a question here. I'll go and see it. Oh, thank you for providing the link. Thank you so much. So that inventory checklist is very good, very how could I say, very complete. And anyway, you'll have my email address at the end of this presentation, but you're more than welcome to reach out to me. I can put you in contact with my colleague based in Edmonton, but we can help you exactly identify how you can protect your IP assets. And we know there's a lot of confusion, so we're there to help you realign and identify exactly what you can protect. So, okay, this could be a bit more difficult to do. So it's assess and rank your IP assets depending on the ownership and potential restrictions. Let's say you own, you've been developing new technology. I'll just, sorry for interruptions, but I want to make sure I don't miss any questions. Oh, yes, absolutely. So Lisa, my colleague, is giving you links to our website as well to build your strategy, which is a very good document as well. So first, with your IP assets, make sure you do have the ownership. And one restriction could be when you're hired by a company to develop something, either artistic or technology or material like newspaper articles. If you're paid to perform some work, and at the end there's some creativity, okay, no matter what it is, whoever pays for the work to get done, whoever pays your salary owns the IP. So you may not have the liberty, the freedom to use it commercially. So make sure you do have the ownership on your IP asset before you file for protection and before you use them. One thing also that could be also difficult to evaluate is the value over time. What may seem like a very promising technology right now in the next year or two may not be as exciting in 3 to 4 years. So in that case, is it worth spending thousands of dollars, well, on IP protection, or you just go, for example, applications on a cell phone, not many people really apply for patents because they're more expensive. They will more rely on the branding, the marketing, filing the trademark over a patent. So that's part of the discussion we have with clients when they don't know how to protect their new product or service. And software apps are a very good example of where most of the conversation we have with clients will reside, because it's very complex. And of course, like the scope and relevance to whatever you're offering, ask yourself the question, are people ready to pay to buy my products or to use my services? And if so, how much? And is what I'm thinking about, is it relevant? Will it be popular with clients? Do some test markets, because we never know. We've seen it before, but we think we've got this great idea, and then turns out that either it exists or it's not as relevant as we thought it could be at the beginning. Any questions so far? Okay, so one thing to keep in mind is whatever you have in mind, make sure that you've done your research. Either you've confirmed that there's no IP interfering with your activities, that you are at freedom to operate, and or that you get the authorizations to use any IP of your not your competitors, but any other companies. What you want to do is avoid lawsuits. And from experience, like as I said, I've been with CIPO for close to 14 years, many infringement, many counterfeiting is done, I would say, by a lack of knowledge. People will use a name or will use a technology not knowing it's protected. So most of the time, it doesn't even go down to lawsuits. It will sometimes resolve itself by a cease and desist letter or a simple connection with the individual and say, I'm sorry, but I do have IP protection on this, so I would ask that you stop using it. But also, as a word of wisdom, I can tell you that many of these cease and desist letters are scams. It happens at least once, twice or 3 times a year that someone will contact me and they say they just got a cease and desist letter and they're just panicking and wondering what to do. And most of the time they're from American companies. So I asked the person, ask them for the Canadian patent, ask them for the trademark, the Canadian trademark. because we didn't get into this, but IP protection, aside from copyright, is national protection. So a patent in the States doesn't protect the technology in Canada. So I would say 90% of cease and desist letters or threats are abandoned because they can't provide a Canadian document, which means if it's protected in the States, but not in Canada, it's free to use. But still, you want to make sure that you're avoiding lawsuits by using a technology or a name or a design. And exactly the second point is very important, is do your research before you want to launch a product or you want to develop technology any further. We do have databases, so patents, trademarks, industrial designs, and copyrights, and all the IP offices around the world do have those databases too. So they're very useful to determine if the technology you want to develop, to make sure it's very new, but also in terms of offering services could be different because anyone can offer a service. All it depends is in what shape or form you're offering it, okay? Like, for example, let's say you want to, I'm just trying to find, I have a hard time finding examples today, I'm really sorry, but you've got a new app. No, an app is not a good example. But let's say you have in mind a new technology for a toaster, so that with this new mechanism, it toasts, like it's more efficient, doesn't take as long to burn your toast or to toast the bread. By doing the research, you realize it exists already. So before going and developing the technology, the prototype, and selling it, trying to sell, you avoid these efforts. But what you could do though, and it's not over for you, all it is you can improve on what exists already, because novelty of an invention is crucial, but novelty includes improvement. So you can make it even more efficient, more, I don't know, it just doesn't need as much energy to get to the result. So that could be an improvement. And by doing your research, understanding the IP landscape in your field of activity, you can either acquire licenses from other companies, or you can grant licenses to use your own IP. Therefore, you make more money, you increase your revenue. Or by licensing other people's technology or product or service, well, it sort of prevents you from doing a lot of efforts. It exists, you need it, just acquire the licenses and use them to your own benefit in exchange of royalties to the IP owner, obviously. Okay, although I've been talking about databases, I've been talking about novelty, and things to keep in mind. Whenever you file for patent, by and large, it's kept secret for 18 months. So let's say your competitor filed for patent protection on a very specific technology, and you're kind of working on the same thing. You will not know that they filed for IP protection, patent protection, until 18 months later. That's most of the regimes in the world. That's the way the patent system is made, and it's for different reasons. And some strategies could include, let's say you are just about to file for patent for some technology, and you know that your competitors are working on the same element. Well, you can request early disclosure, which means it's easier for you to demonstrate that you've been the first one to file, because patent system relies on the first to file in a country and then in the world by and large. Trademarks, in Canada, we have the trademarks registration system, but also we recognize the first use, the date of starting to use, which is recognized by the common law. So someone using a specific trademark, even though they haven't registered it, it's still somehow recognized, and it could prevent you from using that same trademark. And there's also a difference between the business name, which is more like the legal entity, like incorporation, or in Quebec, we have the Registraire des Entreprises de Québec. So it is more like, it's what allows you to exist as a business, and it's nothing to do with your branding. And then, of course, the copyright database offers many limitations, and one of them is that it only displays the title. You don't see the copy of the work. So if you see a title, let's say, I don't know, some title, well, you don't know what it is. You can only tell if it's a literary work or artistic work, and that's all you know. So you don't know, is it a choreography? Is it a picture? Is it, if it's a literary, is it a fiction book, or what's the content? So you don't have access to that information. So that could be a limitation in order to understand what's the scope, what's the IP landscape. I see there's a question. What should you consider if you are buying or selling a business in terms of IP ownership? If I understand correctly, is if you're buying or selling a business, you need to attribute a value to any IP rights. And that value is established according to many different factors, such as the wealth of the company, the perceived value on the market, the sales, etc. So that's part of the thing you should consider when buying and selling a business. I don't know, Lisa, if you have other thoughts in mind for this. I'm trying.
Not at this point, no.
Okay, it's very technical, and we do, like us at CIPO, we're not the ultimate expert in identifying the value, but we do have what we call licensed experts on the field. So they'll be sitting with you and establishing the value on different aspects, including IP. I hope that answers the question. Okay, I see another comment. Oh, excellent, thank you so much. So, okay. Define what you want your idea to become. Okay, so having your business objectives. So let's say, that's an example I like to use, but let's say I develop a new wireless mouse. So my objective is within 5 years, my company will be #1 worldwide in terms of wireless mouses. No matter what I'll be developing, there'll be mouse 1.0, 2.0, 3.0, whatever. So my objective short term is to identify which countries would be very good for me in terms of IP protection and what's missing out there. But also, okay, I recognize that what I have in mind first for my wireless mouse 1.0 is I can make this, which is very rigid, and it's okay. It doesn't work great, but it's okay. Well, I've developed a new material that's recycled material, and that whenever the user grabs the mouse, well, it's soft enough that it adapts to the shape of their hands. I'm inventing something probably, or it might exist already, I don't know. But so that would be my first competitive edge, my first step of invading that worldwide market with wireless mouse. So what do I need? I need IP rights, I need protection. So in order to be the first one worldwide in 5 years, within 5 years with my wireless mouses is, okay, I'll need to get patent protection, I'll need to get trademark protection, I'll need industrial design protections. I will need all these to help me achieve my business objectives. But I cannot do this alone. I will need hopefully I have a big team with me of marketing people, engineer, Salesforce, whatever it is. So with my team, we'll decide who will manage the IP. It could be done internally. We could build a team that will decide, okay, this feature on the wireless mouse seems very promising. We'll file for IP protection. So you need a team to manage your IP. When you only have, let's say, one trademark, it's fairly easy to manage, okay? But when you're getting into more I would say sophisticated, quote unquote, but more like technology-oriented company, chances are you might get a few, if not a lot of patents, trademarks, and industrial designs. So you'll need to understand how to manage your IP. Is a single Excel spreadsheet suffices? Do I need to hire patent agents? Do I need to hire trademark agents? Some companies hire IP agents to work in their own company, so they just become employees. They're not working in private cabinets. So that could be part of your IP management strategy. So by and large, what are you missing in order to help you achieve your business goal that was to be the first in the world, worldwide, to sell your wireless mouses? Hope it's clear, so don't hesitate to ask your questions. Sorry, I'm just moving. Okay, so one of the things, I said earlier, it's always realigning and assessing if you're okay. Again, is your initial IP strategy or business strategy is still the one you're working on, or do you need to modify as something happened, as new markets developed, or what else? What could it be? So going back to going back to the wireless mouse, if you're planning to sell the mouse in, let's say, half the countries in the world, and you're planning to invade Asia, Australia, Africa, well, mainly, let's say, all around the world, it might be very expensive. So you may not want to seek protection in all these countries. So identify those markets where you are pretty sure to make more money than you're invested in seeking for that IP protection. So make sure you identify those countries, you know them, you have your potential partners, and that they can help you achieve your business strategy. And again, going back to the wireless mouse, how is it so different than others that exist already? How will you become number one? Because it's much nicer, it's smaller, it's made out of recycled material, it adapts to the shape of the hand. Whatever the advantage is or the novelty is, this is what you'll capitalize on to market your product and make sure that people buy it, like it, and talk about it and attract more clients. So what is different with this one? Okay, the new material adapts to the shape of the hand. Well, that could be patented. The design is very innovative for however it was developed. So industrial design. You developed a really cool tagline. Well, protect by trademark. You want to make sure that no one misuse the technology, the design, the tagline. So by being protected, you control the use. Having IP protected provides you with an exclusivity on whatever you protected. So then you can control who uses it, who sells it, and who manufactures it. And something very important too is, are there any standards that are regulating the industry? For example, if you're developing something that's related to green technology, there's standards to respect. Pardon me. On my other life, when I do have time, I'm involved with natural products. And we do have, I don't produce them, but I buy them and I make products out of them. So we need to make sure that they're eco-certified. And to have that eco-cert qualification, it requires exams and analysis, and to make sure that we do respect the EcoCert standards. Okay, so whatever you're offering, selling, manufacturing, and you need to meet standards, that's part of the, how could I say this, the strategy that you'll be building on and making sure that you meet those criteria and that you advertise them. Okay, so hopefully we've helped you gain some more knowledge on IP, because gaining knowledge about IP is very good. It's good. You have to know about IP, especially no matter what kind of business you're in. But connecting the dot is better. So, okay, I do have a trademark. Okay, I have a really cool name. That's a trademark. Okay, I'm developing a new feature for my toaster. Okay, that could be a patent. I came up with this really great recipe for cosmetics. Okay, well, that could be a trade secret, or should I protect it by patents? And no matter the decision is, have you choose one of the two for the right reasons? So knowing what to do and how to do it is much better too. But so you have to know about it and you have to know how to use it. Okay, does that make sense? All right. I can stop for 10 seconds time to take some water, and then if there's any questions, I'm more than happy to take them. All right. Okay, so of course there's no one type of IP strategy. And the type of IP strategy you'll adopt is based on different factors, mainly how do you feel and what's your personality and what are your needs. For example, you can have a very offensive IP strategy, which means you will file for many IP protections, probably patents and whatnot, trademarks, but I would use the example of patents. So you will file for patents or you'll acquire patents, but mainly to prevent people from operating their own patents. Sometimes it's for the right reason, sometimes it could be debatable, but so you will make sure that you own enough patents to prevent your competitors from using part of their even their own patents, because it's very technical, but most of the patents rely on existing patents because they're evolving over time and they're using known technology. So in order to, sometimes for a patent owner to exploit their own patents, they need to obtain freedom to operate from different patent holders, unless they're exposing themselves to infringement litigations. On the other side, you can have an IP portfolio just to be defensive. So which means you're making sure you can operate within your jurisdictions, and you sort of, not that you don't care, but you don't pay much attention to your competitors. You just want to make sure that you're safe to navigate in that IP field. And of course, as I said, you can either grant or acquire licenses. Granting licenses will help you increase your revenue, because people in exchange of your technology, your product, your service will make money and will pay you royalties. But you can also acquire licenses because you're needing that. You've got some IP missing and it exists. So instead of reinventing the wheel or working or developing during a year something that's improved, well, acquire the license and just be more functional. And it's known that having an IP strategy will help you obtain more financing. More and more banks, investors, risk capitals, etc., will be more inclined to provide financing when there's an IP strategy, even for federal and provincial programs. And you don't need a 10 pages IP strategy. What you need is, okay, Mr. Investors, I'm planning to develop this new wireless mouse and to become the world leader within 5 years. So here's what I plan to do. I plan to file for patent protection in Canada, US, and Europe maybe. I plan to, and I've got this really cool tagline, cool name, cool logo that I'll file for trademark. So that's all in the plan. And this is how I intend to do. And once I've got my patent pendings in Canada and the States, I plan to seek for distributors, manufacturers based on my patent pending. So it's more interesting for an investor to have an IP strategy that's being thought of, as opposed to someone who just, sorry, I'm getting many emails, sorry. So it's much more interesting for investors when they see that the IP strategy, same as for the business strategy or the marketing strategy, is aligned and makes sense with the ultimate business objectives. Then there's work that was done, and it's probably a factor of success much more than if someone hasn't really thought of it and just say, oh yeah, I'm going to file for patent. Of course, I'll get my trademark, but it's not well thought of, if I may say. So a bit of summary. So maybe I'll stop here just for a few seconds, making sure there's no question. Okay, perfect. Okay, so first and foremost, you have to establish an IP policy as an IP owner. So IP policy / IP strategy is, what will we do? We'll just keep our IP assets for ourselves. So will we try to grant licenses? And of course, okay, in the course of your research or you're developing the markets, you will have to talk to other people. So first, with your employees, you will have to have what we call confidentiality agreements, making sure that those employees will not disclose to the public, to their friends and family, what they're working on. And also with potential partners, collaborators, etc. Same thing, non-disclosure agreement. And something that could be tough to do is to assess the commercial value of what has come out of that research and development. And one entrepreneur once told me, I thought it made really good sense, was that, and even internally, the commercial value is difficult to assess because your engineer will attribute a value. Marketing will attribute probably a higher value. Accounting will say, oh, no, it's worth only money we've invested. So attributing a value could be difficult, but there are experts out there to help you. So of course, developing that IP strategy is, what have you created? What are you ready to put on the market? Are you sure you're protecting the right way? What's your budget and how will you protect them? You don't protect a trademark, like let's say a logo or a name for a product, by a copyright. And some people do. I do have sometimes clients calling me like, oh, well, I protected my trademark by filing for copyright. Well, it doesn't protect your trademark as well as a real trademark right. And it's important as an IP holder to do regular research, what we call, now the word escapes me, but intelligence gathering. Keep searching the patent databases, the trademark databases, to try to understand as much as possible what your competitors are doing. What is the IP landscape? What is coming out in my field? So going back again to the wireless mouse example, I should know who my competitors are, and I could check, okay, well, let's say Microsoft is filing for a patent for a different wireless mouse. Is this better than mine? Can I improve on it or whatever? Or are they infringing on my patent? So those are the questions you can ask yourself. It's not an easy work, it's a regular work, and there's no, again, right or wrong answer as to how often you should do that research, but it always depends on the complexity of what you're developing and Yeah, and on the scope of your IP portfolio, if you have one trademark, it's fairly easy to monitor. But if you have a whole lot of patents and trademarks and natural designs, it may require more efforts. So of course, the right contracts align is a good strategy. Whoops, sorry, to make sure that, again, ownership is clearly defined. If you have employees working with you, sorry, I'm going to the questions in a few seconds. If you have employees working with you, make sure that they know that they don't own the IP, that it belongs to whoever paid for the work. Okay. Okay, sorry, what is a provisional patent? That's a very good question, Charlie. Thank you for asking this one. Sorry if okay, so provisional patent. In Canada and the States, and I'll use provisional is in the States, so I'll use the American example. You can apply in the States for what we call provisional patent, and it costs roughly 200 American dollars, if I'm not mistaken. So it's a patent that is not complete. You have 1 year to complete the work and the drafting of your patent application. And let's say you file for, okay, any technology, whatever it is. The thing is, you have to be pretty much sure when you apply that your patent is, however provisional, it's not complete, that it's almost complete, because you cannot add a new feature to your invention. Let's say in the course of the 5 to 6 months following your application date, you discover that, oh, what I thought would cook my toast faster, well, it can also do feature B and C. Well, you can't add to the patent. It would have to be a new patent application, unfortunately. So provisional, by and large, is giving you 1 year to get your filing date, which is fundamental in patent world, is that because we need an invention that's new to the world to get patented, what you have to do is, when you're almost sure that your invention is close to, I'd say, perfection, you can file for it, and then you have 1 year to complete the drafting and just confirming the anticipated results. So that's a provisional patent. How often should entrepreneurs revise, reassess their strategies? That depends on so many factors. It's almost a case-by-case question. As I said, someone with only one trademark may not need to reassess very often, but anyone, so it depends. And it depends on the events that happen. For example, pandemic was a good example of, okay, we have to reassess what we're doing. So there's no set answer for this. I'm really sorry, Aricia, if I can't really answer this one, but it's really, as I said, it's a case by case. And it's whenever they feel that it could be updated, whenever they feel, oh, there's a new competitor. Okay, there's only me and my main competitor. Now there's a third in business providing the same type of services or product that we do. So what do I do? Do I try to acquire them? Do I let them go? Do I just, okay, I'll focus on something else? So it really, really, really depends. I hope I managed to answer the question. Okay, so I think that's the link that Lisa sent you, but that's a very good guide that CIPO offers on our website. And it's to help you at least with the first steps of an IP strategy. Like, what is it that you're offering? What is it that you're selling? What are you manufacturing? What are your intentions? And so they will tell you, okay, you should file for patent or trademark, and et cetera, et cetera. So it sort of helps you start with an IP strategy. And as I said, I've got colleagues across Canada, and that's what we do also, is we help you. We will not develop the IP strategy for you, but we will give you guidelines, and we have different tools that we can have also to help you at least go further than what the tool can give you. But it's what we like to do is, okay, that's your business goal. Okay, so you need trademark, you need patent. And when do you need to file? So we'll sit down together and we'll discuss these, and I'll ask these questions. So will my colleagues. So that's a good one. So again, going back to planning a trip example. If you're planning to be the first worldwide with your product, well, make sure that your IP is aligned to help you and to guide you, and they're following you and it's there to help you achieve that objective. So make sure that your IP is heading in the same direction, okay? Because that's very important. So in this, oops, I see, okay, there's another question. Client generate, okay, so Lisa just shared the link for the IP strategy guide. So you'll have all these, you can check for them on our website. So by and large, in developing an IP strategy and implementing it and keeping it alive is identify your own IP, be familiar with the IP around you and with the IP landscape, not only around you, but in the countries where you want to seek protection. Is there any IP gaps in your field of activity? Is there something you can develop that will fill that gap? Create your plan, have your plan ready, and make sure it's flexible and that you can use it and you can adapt it to new realities. Implement it. Are you going to be aggressive? Are you going to be more defensive with your IP? And will you seek financing? Will you try to acquire licenses, to grant licenses? And of course, one thing I didn't mention all through this presentation is, as the IP owner, you must monitor your IP. CIPO and other IFISs around the world do not monitor counterfeiting or infringement. It's yours. Hence the importance to establish a really good network around the world when you're active, because you want to make sure that, okay, you file for IP in the States or in France or in Belgium. You want to make sure that you've got enough people, most of the time clients, manufacturers, distributors, agents, working with you, monitoring the market, because you can't be at all places at all times. So you need those reliable networks of people to help you monitor and keeping an eye on your IP. So something I didn't mention, okay, I'll go to the question. Yes, the question is, working with a CIPO advisor is confidential? Absolutely. We're bound by secret. Whatever conversation I have with clients is confidential. And in fact, been working from home like everyone else for the past 15 months. If I'm alone in the house, that's fine. But if I'm not alone, my door is shut and no one is allowed to come in the basement, just in case they hear something. So that's part of this secret that I can guarantee to my clients. And no, it's secret. Don't have to worry about it. And in fact, you have to tell us what you're doing if you want us to provide the right information. And here I want to illustrate what kind of services CIPO offers for free before you file for IP protection. So we have a client service center. So they're the colleagues that are on the phone and on emails all day long. So they will help you understand decipher the different IP rights. So you have a logo, how to protect it, for example. And they will guide you or give you answers on the status of your application. I don't have that access. So even if you contact me, I will not provide you unless it's more general, but by and large, you're better off calling the client service center. And if by completing an application online, you're running into issues you don't understand, you're not quite sure where to go or how to go, call them. They will really, really help you. As for myself and my IPA colleagues, so we have, well, you'll see, but we're across Canada. We delivered those training sessions at this one this afternoon. We will discuss the strategic value, and how to create an IP strategy. So that's the kind of work we do. So we do one-on-ones, as I said, and webinars, seminars, etc. So this is us. I didn't put everyone's email address, but so from Vancouver to Halifax, we're fairly present. If you're located in one of these regions, don't hesitate. You have my email in the next slide. I'll connect you with that individual without any problem. And we do the same kind of work, so you can reach out to us whenever. So this is how to reach CIPO, Client Service Center number. It's a toll-free number. You have my email address. I didn't mention, but what I do is I cover National Capital Region, so from Ottawa, Gatineau, Northern Ontario, and the province of Quebec. So from Kingston to province of Quebec and Quebec. We're active on Twitter, LinkedIn, and Facebook. So you're more than welcome to follow us and look at our activities. There's a QR code if you wish to use it and evaluate today's session. And at the same time, I can take other questions for the next couple of minutes. Okay. So is there any questions? I hope I didn't bore you or put you to sleep while this.
I don't think you bored anybody. I've been part now of a number of CIPO presentations, and I found this one particularly interesting. One question that had come up in a long ago CIPO session was what to do with how to modify your strategy if you've sort of split up the business. Either you're joining with somebody or maybe you're separating a business. Where do you go with that? Do you have to then?
That's a good.
I would imagine that's.
And again, there's no set strategy, but let's say, okay, let's say you're splitting the business. So there are two partners and you're splitting. Well, one might keep the trademark, let's say. So purchase the trademark from the other partner. Same with any other IP that might have resulted from the years of operating that company, and can grant a license. I'm trying to be creative here. There's so many different options they can adopt. And again, it's also right at the beginning is who owns the IP? Is it Lindsay and Carolyn Inc. that have been in business together for 20 years? Or is it a holding that's like above us? Or is it, so all this will determine how to negotiate that giving away the IP or to handle the IP within former partners.
There's so much to think about. Does anyone else have any other questions?
There's either a comment or question here. I'll just see. Oh, thank you, Rissia. Thank you so much. I'll stop so I can see. Yeah. So if anyone has other questions, I'm here.
Well, we'll wait and see if any more come in, but thank you very much, Carolyn. It was a great session.
And thank you, Lisa, for being in the background there. So PDF will be distributed to participants. Excellent. So yeah, if you want to reach out to your regional IP advisor, let me know and I'll just put you in contact with them.
Excellent. And if anybody has any, wants to check out our website as well, we have a number of resources in our resource section, and that includes past CIPO webinar events. And some of them were specific to different topics, like trademark or traditional knowledge was a really interesting one. That one is in English, and there's a French version as well. So lots of resources, and also the CIPO website just has a ton of stuff on it. So reach out to us if you have a specific question as well that we can help get you answered.
Super.
Thank you for coming, everybody. Best of luck to your Habs, Carolyn, and our Jets will see you on the ice in a few hours.
Absolutely. So enjoy the game tonight.
Thank you, everyone. Have a wonderful day. Thanks.
Bye.